Hello everyone, my name is Utkarsh Yadav and I'm a fourth year law student at University of Allahabad. Today we will be discussing about the concept of marriage under the Hindu Marriage Act 1955. So before delving deeper into the concept, let us first understand what marriage actually is. Marriage is a union between a man and a woman for the purpose of procreation or to add generations to the society. It is an institution to protect the society from immorality, unchastity, and bastardization. One of the major concepts while understanding the marriage under the Hindu Marriage Act is its nature. I have divided the nature of Hindu marriage in two parts. First is the pre-act era, which you can say before 1955, and the post-act era. Before the pre-act era, there was no codified law to regulate the Hindu marriage, as we say, and the marriage in Hindu law was governed by customs and tradition. And yes, we all know that marriage was treated as a sacrament. Why I'm saying that we all know this? Because we have heard our parents and our relatives, everyone says that marriage is a permanent union. It is an eternal bond, सात जन्मों का रिश्ता, which we say in Hindi. So, which can also be deduced by the fact that there was no concept of divorce before the HMA was passed by the legislature. And second thing is that since the marriage in Hindus is solemnized by performing religious activities like chanting of mantras, kanyadan, saptapadi, it is a very well known fact that it is considered as a permanent union, an eternal union, and a sacred union. Now, what changed after the act was passed? And when I say act, I mean the Hindu Marriage Act of 1955. The Act of 1955, which is in this context the Hindu Marriage Act, it introduced a modern concept of marriage in India. Why I'm saying that? Because Hindu Marriage Act of 1955 introduced the concept of divorce and it included the concept of pre-consent in the marriage system. If we will compare the two systems, in the pre-act era, the marriage was governed by the customs and traditions, and obviously after 1955, it was regulated by the Hindu Marriage Act. So, we have just discussed that before 1955, marriage in Hindus was considered as a sacrament. But after 1955, the nature changed a bit. The change was that the Hindu Marriage Act treated the marriage as a contract between two parties which can be dissolved. It introduced the concept of divorce, as I already told you that, and also the free consent. If consent of either party is not free, then the marriage which resulted through that agreement would be voidable on behalf of that party. So we have seen two aspects of the same coin. At present, Hindu marriage is a mix of both. Now, since the topic is marriage under the Hindu Marriage Act, there's one section, Section 5 of the Hindu Marriage Act, which tells us the essentials or the conditions of a valid Hindu marriage. This is a bare provision of that, but we will discuss each subclause in the coming slides. So if we see, a marriage may be solemnized between any two Hindus if the following conditions are fulfilled. It is the bare provision. First, that neither party has a spouse living at the time of the marriage, pretty self-explanatory. Second, at the time of the marriage, neither party is first incapable of giving a valid consent, since I told you that this act specifically sees marriage as a contract. Second is, even if any of the parties capable of giving a valid consent, they should not be suffering from a mental disorder of such a kind which makes them unfit for marriage and procreation of children. And the third clause is that any party he or she is subject to recurrent attacks of insanity, then the marriage will not be considered as a valid marriage. But you should know, if any of the parties develop some kind of mental disorder or unsoundness of mind after the marriage, then it cannot be said that it is in violation of Section 5 of the HMA. Section 5, Clause 1. I assume that you have the BALLB while watching this video. So, as per this section, neither party should have a spouse living at the time of the marriage. In contravention of the given condition, the second marriage will be void under Section 11 of the Hindu Marriage Act. We know that a marriage is dissolved mainly by two situations. First, death of either party, and second being when a divorce decree has been granted by a competent court of law. When these situations are not there, first being death of either party, second that divorce has not been granted, and either of the party marries another person, then the subsequent marriage will be void under Section 11 of the Hindu Marriage Act. I hope it is clear. Alright, now let us understand the concept and the effect of apostasy in the Hindu marriage. Apostasy is basically the renunciation of your own personal religious belief. We will understand this concept by the landmark judgment of Sarla Mudgal versus Union of India. The facts of this case were that three Hindu male who were married converted to Islam and married three women who were also converted Muslims. The issue before the Supreme Court was that whether this conversion will result into the automatic dissolution of the previous marriage solemnized under the Hindu law, and whether the validity of the previous marriage will have any effect from this conversion. So the Supreme Court clearly stated that conversion of either of the spouse will not result into the automatic dissolution of marriage previously solemnized under the Hindu law. In no manner it will affect the validity of the marriage, and the marriage will continue to subsist and will continue to govern by the provisions of the Hindu Marriage Act. The second marriage solemnized under the Muslim personal law would be void, and the husband will be liable for the offense of bigamy. Now, Section 5, Clause 2 discuss about the condition regarding the mental health and soundness of mind. If at the time of marriage, I have already given emphasis on the phrase at the time of the marriage, and I am again reiterating it, that if at the time of the marriage a party is incapable of giving a valid consent due to unsoundness of mind, then such marriage will be voidable under Section 12. Also, if a party is suffering from mental disorder of such a kind so as to make him unfit for marriage, or he is subject to recurrent attacks of insanity, then also the marriage will be voidable. Now, let us come to the conditions regarding the age. It is pretty self-explanatory. The bridegroom should not be less than 21 years of age, and the bride should not be less than 18 years of age. But there's one interesting thing about this section, that Hindu Marriage Act only makes child marriage punishable under Section 18, but it is silent on the validity of such marriage. So before 2006, it was a really hectic question before the court as to what will be the validity of such marriage. But this position changed after Prohibition of Child Marriage Act of 2006 was introduced. Conditions regarding prohibited degrees of relationship. What is this prohibited degree of relationship, you may ask? You may go through this chart which I have inserted in the slide. This is the prohibited degree of relationship, where it is prohibited to marry, unless the custom or usage governing each of them permits the marriage between the two. And in violation of this section, the marriage shall be void under Section 11, and the concerned parties shall be liable for punishment under Section 80. This slide talks about the conditions regarding subgender relationship. You may go through the chart which I have inserted. The parties to the marriage should not be subindas of each other unless the customs or usage governing each of them permits a marriage between the two. And in violation of this section, the marriage shall be void under section 11, same which we have already read. All right, so this is the final slide. What are the types of marriage we have understood? What we have understood till now is what is a marriage, what is its nature, and essentials of a marriage. And we have seen that if one of the essential is not there, the marriage is either voidable or void. So let us understand the basic difference between a valid marriage, a void marriage, and a voidable marriage. So a valid marriage, from the name only it suggests, it fulfills all the conditions of a marriage. The legal effect of marriage arises as soon as the marriage is solemnized. Rights and duties of the husband and wife are vested in them, and the parties are deemed to be husband and wife. Pretty easy to understand. Now let us understand what is a void marriage. It is also pretty direct. Parties will never be considered as husband and wife because it is void of initio, and no legal effect of marriage arises, and no rights and liabilities arise. Now, what is a voidable marriage? A voidable marriage is considered as a valid marriage unless and until it is declared void by a competent court. If not declared void by the court, it is treated as a valid marriage, and if declared, it is treated as a void marriage. So I hope you understood what a marriage is and what is the nature of the marriage, what was the position before the act, what is the position after the act is passed, the conditions of the Hindu marriage, and the effect and types of marriage. So thank you very much. I hope to see you soon.